start of a case, it was possible, on the evidence that the court had before it, that the injuries could have happened over a very wide spectrum of time, the vast majority of which my client, the father, wasn't present for. The evidence that we've had from both the experts and the mother has considerably narrowed that time frame, and it's narrowed it to the point where the only potential perpetrators of the injuries, the only two people that had the opportunity to do it, are likely to have been my client or the mother. The parents are still together. The parents are still in a relationship. They are in a very close relationship, actually. They clearly find the relationship they have extremely supportive. And within the context of that relationship, as I say, their case is that whilst they have to acknowledge that the child did suffer injuries, that they did not cause those injuries.
Louise's divorce case has ended up in court. This morning she'll be cross-examining her client's ex-wife.
What he wishes to achieve, which is absolutely not to have to give her a penny, I'm not sure those chances are brilliant. The chances of my case that I'm running for him, which is an equal division, are probably a bit better, although not guaranteed. And we have, for instance, say, 30-page schedule of furniture and contents that actually neither of the barristers nor the judge have sort of made any reference to yet, and we're steadfastly refusing to do so. But at some point the judge is going to have to decide who has taken what furniture, what is the value of what's been taken, what's the value of what's been left, and who should have what's been left. We don't even agree what furniture is presently in their marital home. So that's what's making it very difficult. We just can't agree about anything. Actually, he's asked me yesterday or Monday, do I think they're crazy? The costs in this case are £85,000 between them. Do I think he's crazy? And I said, no, I think you're human. I think you are, it's all very well, whatever, I can look at this with a sort of cold and rational eye, but that's not what this is about. This is the breakdown of a marriage, isn't it? This is, you perhaps would argue about contents if you were grieving and bitter and wounded, and both of them are. That there's obviously a high level of feeling, not positive feeling, but feeling still in that room, I think.
I'm going to start by asking her about what her housing needs are, and we've got a murky cohabitee in the background, and we don't know anything about what he earns. And she says he earns £13,000 a year. She says that she doesn't know anything about what his assets are, even though they've been living together for 2 years. She doesn't know what he got in his divorce settlement. So I'm always a bit nervous, yeah. I think that's helpful. You need a bit of adrenaline in these long cases to keep you going.
This is the judge's chambers where we're conducting the hearing. So it's not in a big courtroom, as probably you normally imagine. That's where the judge sits, and I've been sitting here. So I sit here, my client's there, my solicitor there, and then ranged along the other side of the table are the other parties. And then when people have been giving evidence, they've been sitting at the end of the table there. I think it's probably better for the parties to be in a room like this. They're probably more relaxed, but it's actually harder for us. It's quite intimate, you're sort of cross-examining somebody that's just sitting virtually alongside you. You haven't got that kind of space. We've also got 5 bundles that, trying to fit them all kind of on here and around you is not so easy. So I have to say, I prefer being in a courtroom which is a shame because most of my cases are conducted in a room like this, or smaller actually.
Morning, Alistair.
Morning, how are you?
Tired.
Yeah,
Too late tonight, too early in the morning.
I was 4:15 this morning.
5:30, I'm
Very
afraid.
good.
Not that it's a contest.
In common parlance, I think we're on a sticky wicket. We have also a situation now that I've received the mother's written closing submissions overnight, and she appears to have changed her instructions to her legal team, and those submissions argue for a finding against the father. So that is also something that we're going to have to deal with today, first in conference with the father, and then I'll also have to deal with that within my closing submissions.
And the Guardian's position, you'll see, is still neutral.
Okay, thanks for that.
Right,
I will,
I'll have a look at yours now.
Yeah, I'll
Well,
take some instructions, and if there is any change in light of the mother's position, I will let you know. All right?
The mother's position during the hearing was that she did not expressly say in evidence that it was the father, and she was pressed as to whether that was her view. She was pressed by me, she was pressed by others, and she wouldn't say it was him. The way in which the case has been put has implicitly suggested it might be him, but now the written submissions in fact expressly say that it's the father. So the mother is now putting forward a case which is inviting the judge to actually make a finding that it was the father. So that is a significant change in stance. And I think it's rather surprised Alistair.
I'd been cross-examining the wife for about half an hour, 40 minutes, and she just needed a break. We all needed a break.
Yes, yeah.
So, yeah, it's quite uncomfortable in there for her, I think. It's fairly unpleasant.
We're in court. My wife is being cross-examined by a barrister. It's quite upsetting, really, to see someone you once loved being torn to pieces, you know?
I think there is an element of thinking, oh gosh, you know, this was a marriage and now it's come to this, sitting across other sides of the table and, you know, paying my barrister to rip her into shreds, you know, which I don't think it's very dignified for anybody, but I'm afraid it's what the case has come to and what the personality involved has kind of led to, I suppose. But, you know, there were a few moments where she gave evidence, didn't she, saying, yes, he was a very good husband, he was very supportive, he was a very helpful husband, and I just thought that must have rung such a chord with him.
Yeah,
And
I think that was when he got sad.
I'm sure he did get sad then.
We're almost home now.
This is my chauffeur. As a fat cat barrister, obviously, I employ a permanent chauffeur to drive me around wherever I want to go. It's my husband, Richard, who has also been in court in Birmingham today. So it's quite nice. We drove in together this morning and we can drive home together this afternoon.
The divorce case has ended with an equal division of the matrimonial assets.
This is Martha.
Oh, gorgeous girl. And she's quite pleased to see her daddy, aren't you?
Come on, Martha.
Good girl.
As you can see, it's pretty much done. Give or take, you know.
Just a bit.
All
bit of
over by the
window dressing.
shouting.
Just a bit of window dressing required. That's where we work, at that table.
No, neither of us touch alcohol. That's just we have in case somebody comes around who insists on having a drink. But we're both teetotal. Most barristers are, actually. I find a cup of chamomile tea and a hot bath to be the best way to relax in the evening. Don't bother with alcohol. Perfect.
Louise's client may have had his day in court, but it has cost him over £50,000.